Hello, my name is Matej, and I will just say a few words on other aspects the code brings, namely on changes it brings on the functioning of the national regulators and their clubs, namely BEREC, the Body of European Regulators for Electronic Communications, and RSPG, the Radio Spectrum Policy Group. So what are the main changes when it comes to institutional setup is that the first one is, which in the current 2002 framework was not there, that some of the tasks, the regulatory tasks within the code are now specifically entrusted to the NRAs. Before, there was much more possibility for member states to put even those tasks in the hands of other competent bodies, whether that would be other agencies or the ministry. But now some of the tasks are specifically reserved for NRAs, PTA in the Icelandic context, and I will explain in a minute why that is. The independence of the national regulators has been further strengthened. Even in the 2002 framework, it was already recognized that for the effective functioning of some of the regulatory functions, independence had to be ensured both from the sector side, so from the industry, but also from any sort of political pressures as well. Then the third one, which didn't really work out as much as the Commission wanted, the Commission always wants to harmonize more, wants to make sure that there's a unified internal market for telecom. So that's why it wants to increase the power of BEREC as a European agency, but it didn't really work out. The member states always push back and demand that the main regulatory functions stay with the national regulator who can address national circumstances in the most appropriate way. And the third one, the RSPG, the last one, the RSPG, Radio Spectrum Policy Group, has been given a bit more, a bit bigger role to ensure increased cooperation, to ensure more coordination when it comes to issues like harmful interference. And there is this peer review process where national assignments of spectrum, so national auctions where spectrum is given to the operators, were supposed to be reviewed first by BEREC, then it was put into the hands of the RSPG, but it was further watered down. Now it's a completely voluntary process without any real teeth behind it. So, NRAs. When the code talks about national regulatory bodies, it talks about bodies which are independent both from the sector and from any external political pressure. And there is this duality, which I already mentioned. Some of the tasks are specifically reserved for NRAs only, while other tasks may be done either by NRAs or by other competent bodies. And why that is? It is because the code specifically ensures a higher level of independence for NRAs than it does for other competent bodies. So there's this thinking of the legislator that some of the most sort of sensitive tasks, such as market regulation, market analysis, dispute resolution between operators, it should always be done by the NRAs. And there's this whole range of provisions which are supposed to ensure that they are able to act independently, objectively, and impartially. And one of the main things that the code says about this is NRAs should have adequate financial and human resources to do all their tasks, which means they have to have a separate annual budget, and within that budget, a certain degree of autonomy on how to dispense that budget to make sure basically that they can hire enough of highly qualified people to do all the tasks necessary. And This applies also not only for their national work, but also for their international cooperation within BEREC, within RSPG. The code specifically puts an obligation on member states to ensure that the necessary resources are given to the NRA to also do those international tasks. The code also ensures the independent or the impartiality of NRA's decisions in terms of appeals. So any appeals against the decisions of the regulator should only be heard by the independent and effective appeal body. Now this may or may not be a court, but if it is not a court, as if I'm told is the Icelandic example, there's this appellate committee, then there has to be another step above it, which is a judicial review. So in the end, the affected operators on one side, and on the other side, of course, the NRA as well, if it's affected by the appeals decision, has to have a possibility to have their case heard in front of a court. And there's this whole range of rules now in the code about preliminary injunctions against regulatory decisions. If you read the recitals to the code, it seems that there's a big discrepancy in the practice of member states, how they treat or how they're likely the appeal bodies are give preliminary injunctions against regulatory decisions, meaning that they suspend regulatory decisions until the appeal is actually resolved. And because of these big discrepancies, now the code specifically says that any sort of suspensive decisions have to be only reserved for extreme cases, only where there would be immediate and irreparable damage for the parties involved, only in accordance with the practice of European Court of Justice on when the preliminary injunctions should be given. So this should really be an exceptional case. And to further harmonize the approach of member states on it, the NRAs should report on Commission's or BEREC's request on the number, subject, duration, and specifically on the decisions that suspend regulatory decisions. They should provide this information to the Commission and BEREC, and the code mentions the possibility that this will be put into database to provide the Commission with the possibility to see if any harmonization is being made in that respect. Now the code also brings new rules on appointment and dismissal of NRA heads. Specifically, the current framework did not really have any rules on the appointment of of the heads of regulatory bodies, whereas now the code says that any selection procedure to choose the heads should be an open and transparent one, and that the bosses should only be appointed on the basis of merit, skills, knowledge, and experience, and not anything else, such as political affiliation or anything like that. And their term should be at least a 3-year term. There are also strengthened rules on dismissal. The code says that a head can only be dismissed if they no longer fulfill the conditions laid down in national law before their appointment. So their dismissal should not be an effect of any concrete decision that a national government might not be in favor of. Any such dismissal decision should be made public and should be a subject to a judicial review, both on procedural points and on substantial points. And this also is new. I think this is a direct consequence of practice in some of the member states where they used to, because of less than stable governments, which were changing quite fast from year to year. Coincidentally, every time that the government would change, the head of the regulator would be changed as well. And this led to quite a few infringement procedures against those member states, which some of them even resulted in fines. So now these rules have been strengthened with a view of preventing such situations in the future. Now, I mentioned this before. I won't really go through all of them. These are the 12 tasks that the code now says can only lie with the national regulator, most notably the market regulation and dispute resolution. There's only 12 of them. The European Parliament in the legislative process, they wanted more powers to be given to the national regulators, but once again, the member states wanted to have flexibility to give some of those tasks, most notably spectrum issues, also to ministry or to other bodies. And now, as you can see on spectrum management, it's only the advice on market shaping and competition elements that have to be with the national regulator, whereas everything else in terms of spectrum assignment can be also done by the government itself or by the ministry. A few words on NRA funding. So when it comes to NRA funding, there's basically three main sources of where NRAs in Europe get their money from. The first one is administrative charges, which is a part of this general authorization regime, which I will explain. The second is funding from giving access to scarce resources, namely numbers and spectrum. And the third one is general telecoms taxes, which are being used very, very rarely in Europe. Also, in terms of proceeds from spectrum and numbers, it's much more common that this actually goes into the general state budget, whereas it's more common than not practice in member states that administrative charges collected by the NRA in this general authorization regime stays with the NRA and is the main source of funding for the regulator. A few words on this general authorization regime. What does it mean? This is basically the administrative approach for market entry for the provision of electronic communication networks and services in Europe. What it means is that if somebody wants to start providing networks or services, telecoms networks or services in Europe, the only thing they need to do is notify the regulator that they plan to do so. So there's no licensing regime allowed in Europe. There's no specific administrative act or decision by the regulator or by the ministry needed before services can be provided. The operator just needs to let the regulator know, we're going to start doing this. And then the only thing that can apply are conditions that are listed in Annex 1 to the code. And one of the main conditions or obligations that apply to operators is this administrative charges. Now, the code specifically says that those administrative charges may only cover the costs of management, control, and enforcement of the general authorization system. Then the code goes in a bit of detail. It says things like market analysis, also international cooperation, the enforcement of telecoms legislation, consumer protection. All those tasks may be covered by the administrative charges. They have to be objective, transparent, and proportionate, and there can be sort of a de minimis rule in there where the legislation can say, okay, if somebody, because usually those are levied on the basis of revenue, of telecoms revenue, and then really small operators can be exempt. For instance, the rules can say if your revenues on telecoms is less than 10,000, 20,000, whatever, 50,000 euros per year, then you're not obliged to pay anything. Now, the code is quite strict as well, where it says that any discrepancies between the money collected and the money actually used to do those regulatory tasks entrusted to the regulator, if there are discrepancies, then the level of the charges have to be adjusted. Meaning, if the costs for overseeing the telecoms market of the regulator is higher than these administrative charges, they can be increased. But if the costs are lower, if the charges are higher than the actual costs of the regulator, they have to be reduced. And this is why every year the regulator has to publish an overview of administrative costs and of the total sum of the collected charges, so they can be compared and, if necessary, adjusted. Now, a few words on BEREC, what BEREC is. BEREC, as such, is not the rules on BEREC are in a separate regulation. They're not really a part of the code itself, but the regulation was adopted on the side of the code at the same time. And as I said before, BEREC is sort of you can see that it's a result of a political negotiations, because it's a very compromised sort of body. It doesn't really have any directly binding decision-making powers. Going beyond what Veronica already mentioned is this double lock veto, whereas if Commission thinks something is very wrong and if BEREC supports it in only very restricted cases, symmetric access beyond the first concentration point and co-investment, all the other deliverables of BEREC, all the guidelines, the opinions BEREC publishes have to be taken into utmost account by the NRAs on one side, and in some cases by the Commission, whatever it is that utmost account means. And there is an obligation on NRAs to actively support BEREC's goals and to actively contribute to the work of BEREC, and as I mentioned before, to take utmost account of all BEREC deliverables. Now, there's this weird duality of BEREC, because you have this body of European regulators for electronic communications, which is, it's not a real body because it doesn't have any legal personality, but then you have the Office for Support of BEREC, as it is called now, BEREC Office, which is established in Riga, and that part of the BEREC has legal personality. And the BEREC was envisioned as an advisory body on one side to NRAs, but on the other side to the Commission, Council, and European Parliament. And as I mentioned, it issues opinions, guidelines. It may analyze some sort of European issues such as transnational markets and transnational end-user demand. And it must maintain a database on notification and extraterritorial numbers and so on and so forth. BEREC Office, on the other side, is supposed to provide professional administrative support to BEREC, sort of collect and exchange information, disseminate regulatory best practices, and assist BEREC with anything else that BEREC does. EWGs, those are expert working groups of BEREC, and this is actually where the most work of BEREC is done. Those are working groups where national experts come together, sit in the same room, discuss, and then adopt documents, the opinions that then the heads of the NRAs, which form the Board of Regulators of BEREC, vote on. And then just a few words on RSPG, the Radio Spectrum Policy Group, which is a high-level advisory group that assists the EU institutions on the development of broader radio spectrum policy issues. It is composed of representatives of the member states and the Commission. The representatives are usually sort of high-level representatives of whoever is responsible for spectrum in a certain country, so either the regulator or the ministry. And then there are observers in there from the EEA countries, candidate countries, also from other institutions or organizations such as CEPT and ETSI, which is the standardization body. And what RSPG is supposed to do is provide various opinions to the Commission, EP, and Council. On some level, it's sort of similar to what BEREC does on traditional telecoms issues, but RSPG, of course, only extends to spectrum issues. It must facilitate coordination between member states, and one thing which I think might be quite an important role for RSPG is to coordinate and resolve disputes when it comes to harmful interference. Iceland being a little bit isolated from everybody else, I guess has a little bit less issues when it comes to harmful interference, cross-border harmful interference. So there's a little bit less of those issues that would need to be resolved in front of RSPG, whereas some other member states, not only internally where the use of spectrum is more or less or should be more or less harmonized, but the ones that lie at the edges of European Union and border with countries that might have a bit different views on the use of spectrum, those countries might need the help of RSPG a bit more. And then there's this peer review process of national assignments, but which I said has been completely watered down. Now it's a completely voluntary thing, which I don't think will play any real role in practice. And that's it when it comes to institutional setup. Thank you very much.